All right. Let's move on to the WordPress thing. So we've got a motion appoints and authorities on a preliminary injunction motion. And we have this document here from Hogan Lovells contains the most alarming assertions yet by defendants in this case. Frankly, the assertions in this usually throwaway filing are ones that if I was a company working in this space, I would be, or a volunteer working in this space, I would be much, much, much more alarmed about. What is happening? Okay, so background, because that's a fair question, Rachel. Defendants in this case, remember, are Matt. So these are assertions being made by Matt, by defendants. So here's the deal, basically. And you may want to go pull the VODs for this one, Rachel. I know you usually don't because of the time constraints, but oh my god, this is a classic. Let me explain. No, there is too much. Let me sum up. The situation is completely freaking insane. Basically, Matty Mullenweg of WordPress creation fame got very angry at now Matt, it should be said, runs the runs Automatic, which is the for-profit company that does WordPress hosting and other related services. Which is also WordPress.com, runs the WordPress Foundation, which everybody wrongly seems to have thought included WordPress.org. And as it turns out, Matt personally owns WordPress.org. Way back at the dawn of time, otherwise known as, I think, 2011-ish, for various reasons, including the fact that a lot of the underlying code was open source, WordPress was open sourced. WordPress was, and when I say open sourced, in addition to the code, it made a big deal of their transferring all the trademarks to the WordPress Foundation. Fast forward to the present. There are now some indications that as early as February of this year, Automatic, which I understand has possibly been doing better commercially in the past than they are currently, began looking at the possibility of leveraging the WordPress trademarks to hit everybody else operating in the space up for royalties, despite the fact that all of the software is open source. How's WordPress's business doing these days? WordPress powers a huge chunk of the internet still. Now, forwarding a little bit more than February, this is a stick up. Almost literally happens, Rach. Almost literally happens. Okay? So here's what Mullenweg does. You're going to love this. He literally gives WordPress, WP Engine an ultimatum. They have to agree to a trademark license before he goes on stage at the really, really big WordPress event, because if they don't agree to it by then, he's going to go on the stage and badmouth the crap out of them. Yes, really. No, I'm not kidding. Really. So, can we say tortuous interference? And many other things. And yeah, the license agreement was for something like 8% of gross, not net. Which is like half of net. I mean, right? If ever there was. Um, and then making things even better, of course. Um, they block out. They making everything even better. They go ahead and they disable all of WordPress WP Engine's people's access to the WordPress.org repositories, kill WP Engine's ability effectively to push out, like critical safety updates through WordPress.org. Yeah, nope, it's that wild and more. I'm just scratching the surface. Pushes so does that. And Mullenweg has also, while WP Engine was banned from pushing updates, publicly identified a vulnerability in WP Engine, which he was then preventing them from pushing fixes to. Oh, and he used the WordPress dashboard to push speech about how bad WP Engine was to all WordPress users, including all of WP Engine's customers. Oh, I almost forgot the bit where he also said that, they would basically make it worthwhile for anybody to drop WP Engine by with basically big switch concessions. Oh yeah, Neil Katyal got involved in this because Matt Mullenweg decided that a hardcore Supreme Court advocate is exactly the person to lead the trial team in a complex intellectual property trial court case. And, yeah. Oh yeah, he used the vulnerability to take control of... He's taken control of some of them. Yeah, the whole thing is... It would be more hilarious if it wasn't for the fact that this guy is trying to claw back full commercial control of a massive, long-standing open source project that thousands of people have contributed to. And Neil Bill's what, 2,500? So anyway, the first stream I did was on the dispute. In the first stream that I did, I said that I expected a complaint to drop the following Monday or Tuesday, and I think it didn't drop until like Thursday. The second stream I did looked at the complaint. The complaint has some strong claims. It's got some weak claims. It's got an interesting CFA claim that I think is probably a loser, but it's in the, what the hell, it's colorable. It's colorable and you miss every shot you don't take, so why not? With that background, actually, Rachel, do you want to get all your laughing out of the way right now? Because we can actually do the opposition to the motion to shorten time first. This is the one that is, if you've got news on one of the claims being made by the plaintiff, go for it. But the what? WP Engine moved to shorten time to respond on their preliminary injunction motion. And Automatic opposed. So, would you like to cover the papers on this first, or should we cover the... Well, they had reason. WP Engine did not give them the opportunity to waive service. So, through its administrative motion for an order to shorten time, plaintiff seeks to compress defendant's time to respond to the important preliminary injunction motion to a mere 1 week. Specifically, they ask to move the deadline forward to October 25th from November 1st, the date when the opposition ordinarily would be due. The administrative motion comes at the very same time as plaintiff well knows defendants are busy preparing their own motion to dismiss the claims. The motion to dismiss is due to be filed on October 30th, just 2 days before the due date for the opposition to the preliminary injunction motion. Would everybody like the punchline now before we go to the scary part? Because of the overlap between the motion to dismiss, yada, yada, yada. The short fuse deadline will prejudice defendant's ability to respond to the motion, which is over 400 pages and raises many key issues. And yeah, the big law attorneys will have to work too hard. So the judge did not, in fact, shorten time to October 25th. The judge shortened time to October 30th. Lawyers, tell the kids at home how fun that is. Right, Rachel? Okay. It's not that it's a short time period. They were they were moaning and whining about how if you made them respond to the 25th, they wouldn't have enough time between the 25th and the 30th to complete their motion to dismiss, which is due on the 30th. So the judge set both due dates for the same day. Right? And, the judge did this on purpose. Of course the judge did this on purpose. Is that a normal thing? I'm guessing this means the case is going bye-bye? I doubt it. What's the significance? That is just, it's just a small, come on. What are the two motions? Their motion to dismiss and their response to the motion for preliminary injunction. So, two big filings. Two very big filings. And the hearing didn't get moved up to on or after November 29th, which is after Thanksgiving. It's going to be before Thanksgiving. By the way, the judge in this case has been on the bench for a year-ish, give or take. I don't have any feel for her on these kind of issues. So, yeah. Because I think what did it was the summary of the dispute. Because they decided to use, honestly, I think if they had ended it here, on page 3, at line 4.5, I think if they had ended the motion right there, or their opposition right there, probably they would have got what they actually wanted. This is the bit that got the judge to toss the elbow. Because they decided to very heavily drop in an attempt to argue the merits of the case on the administrative motion. So I think that's what got them the mild slap. I'm going to take just a second and see what Local Rule 6.3 is in Northern District. NDCal, local rules, civil local rules. Why do I... Right, because I'm attorney of record in a case in that district. That's why I have a copy. Um, 6 point. Okay, 6 point. What is? Yeah. So I want to see what that parenthetical has to do with anything. Local rule 63A4. Motion to change time, time and content. Five, four, six, two, six. A form. A4 says a motion. Yeah. So what it says is that the motion to shorten time should describe the nature of the underlying dispute that would be addressed and briefly summarize the position each party has taken. But that's what the motion to change time should say. The opposition should the opposition doesn't actually specify that stuff. I mean, you can't shake a stick without finding a case that Quinn Emanuel's huge, so it doesn't really surprise me that there's another trademark dispute in front of the same judge. Not a shock. Doesn't mean anything. All right. The administrative motion's misleading summary of the dispute portrays the case as being about defendants' supposed abusing of their control of WordPress. Not so. The case is not about plaintiffs' access to WordPress. WordPress is open source software that is freely available to the plaintiff and anybody else. Rather, the case is about WordPress.org, and here's the alarming part, a website owned and run by defendant Matt Mullenweg individually for the benefit of the community. If somebody wants to pull the popcorn, I think it's the third one. No, this is not Automatic's response. This is the, this is Automatic's opposition, yes, to the admin motion. But this is the bit that I find very, very alarming from a free and open source perspective. Mullenweg is asserting the sole and exclusive right to determine who has access to WordPress.org resources. And Mullenweg's position effectively is that if he doesn't like you, you can get the hell off WordPress.org and, go distribute your stuff through GitHub or whatever. That is... Yeah, this is exactly Matt trying to take things to a walled background. No, this is so individually, essentially, we know the domain name is personally owned by Matt at this point. I mean, apparently nobody actually knew that or really was aware of it earlier. But it's only hard-coded in 1,500 places for auto upgrades. Yeah. WordPress.org is not WordPress. WordPress.org is not Automatic or the WordPress Foundation and is not controlled by either. To the contrary, WordPress.org is Mr. Mullenweg's responsibility. That's bad. That is fundamentally bad. Particularly if Mullenweg's saying he'll reject any patch that changes the hard coding. We know that a lot of Automatic companies... for that matter, how much user-contributed content is on WordPress.org? And yeah, I read the gambled line. Huge amount of user contributed content. Um, Automatic hiring a bunch of people to work on Matt's personal property. Well, it might be a violation of fiduciary duty, but who's got standing to sue over it? Is that is that income for Mullenweg? I don't know. I'm not a tax guy, fortunately. Automatic employs somebody who's the executive director of .org and it's not part of Auto. Yeah, there's a lot that's going to have to get litigated out here. This is to an extent. So let me tell you a secret about law. And let me tell you a secret about litigation. Not so much a secret as one of the things I've learned in the handful of years I've been doing this now. Literally just, barely a handful. Remember when I said that, credit where credit due, Neil Catchall wouldn't be a bad choice to argue this case if the case was before the Supreme Court? And I meant that. The son of a bitch is many things, including a child slavery, the Wednesday, if you hadn't told me you held the common stock, I might answer that question, but because you did, I won't. Apologist, I think it. Proponent, yeah. Sorry, the Wednesday. Apologist, probably. Anyway, Kitchell is a lot of things, but he's a good Supreme Court advocate. Here's the thing about Supreme Court advocacy. Supreme Court advocacy, you have the record, and he's on this as a power move. No, apparently he's the relationship partner. Are you ready for another laugh? The reason Neil is on the case is because Matt met Neil at Burning Man. So, yes. Yeah, he's the relationship partner. He's not a name that Hogan decided to add. He's the relationship partner. Which means, egos being egos as the relationship partner, he's going to have more. He probably discounted himself from 2,500 to an even 2,000. It means, though, that he probably has more input over this than he should. That was why I'm going into what the difference is between what Neil usually does and this stuff. Because when you've got to actually report up to the big name, when you've got the big name as the relationship partner and you got to report up to that, it does change the equation a little bit, right? So, do I have the excuse to continue on about the difference between Supreme Court and appellate litigation and trial court litigation? One of the big differences is that, generally speaking, on appeal, it's 3 briefs, done. I mean, amicus sometimes, but that's not your problem. It's 3 briefs, and you are writing at most 2 of them. If you are the appellant, you are writing your opening brief and the reply. If you are the appellee, you are writing an opposition. That's it. At the Supreme Court level, 2 rounds, 1 round on the why you should get cert, 1 round on the merits. Then there's oral argument, and you're done. That is a very different tactical and strategic landscape than trial, where in a case like this, you are going to have the preliminary, at a minimum, without a settlement, you're going to have the preliminary injunction motion, at least one round of motions to dismiss, and possibly multiple if there's an amended complaint, some without prejudice dismissals and that kind of thing, and summary judgment motion. That means that an argument like this that's, about control, that might be tiptoeing around the edges of veracity or might sound like a good idea at a time, becomes a lot less good idea when the other side has 18 opportunities to beat you over the head with all the weaknesses. So I could kind of see that this is not he's the one who has the personal control, not the company, being a great point on appeal, potentially. But it's not, it's the kind of thing that can come back to haunt you and bite you in the ass in a trial court. So let's see. WP Engine points to no terms, conditions, or permissions that entitle them to such access. Yeah, weaknesses of open source. Nevertheless, WP Engine, a private equity-backed company, made the unilateral decision at its own risk to build a multi-billion-dollar business around Mr. Mullenweg's website. Oh, how does that make you feel, WordPress devs? Building a WordPress hosting business is building a business around Matt Mullenweg's website. That's what he says you're doing. Open what? In doing so, WP Engine gambled for the sake of profit that Mr. Mullenweg would continue to maintain open access to his website for free. That was their choice. Now, because of WP Engine's conduct, because of the threat WP Engine poses to the beloved community Mullenweg has worked so hard to build, and because of WP Engine's legal threats and actions against him personally, Mullenweg has decided he no longer will provide free access to his website to the corporation that is suing him. Understandably, WP Engine is not happy with Mr. Mullenweg's decision, and the lawsuit is their attempt to use this court to compel the access it never secured by contract and has no right to by law. Words like a reliance are absolutely going to start showing up. This is, all the promissory estoppel is in play here. And then some. Plaintiff will suffer no grave harm under the other briefing schedule, which they talked about for more. Defendants, yada, yada, yada. And they used all 5 of the 5 pages on their opposition. So, yeah. Does it look like WPE is going to try to pierce the veil? What veil? Like, no, literally what veil? I don't know what the distinctions are between the companies to even tell you where the veil might be. That was an incredibly damaging document for WordPress, Automatic, etc. that was submitted on their behalf by their lawyers. Illuminous, I'm a lawyer who flunked out of the computer science program in 1990, what was it? For sophomore year was when I started and finished the CSI major. So yeah, End of December, somewhere in December of '94, after 18 hours of not getting the Eternal Calendar to compile, I realized that the coding stuff wasn't for me. But just speaking as a lawyer who, has a fairly solid background in open source, my personal opinion at this point is that it's fork or die. How far did I get? One semester. All right, let's look at the let's look at the motion of law, the memorandum of law on the preliminary injunction motion. So we've got there's promissory estoppel here and everything, I think, very strong. But anyway, let's move on. Legal standard for a preliminary injunction, because I'm going to skip that page. It's all the way down to page 16. And we're going to skip a lot of the fact section here. In order to for the non-lawyers, a preliminary injunction is early relief in the case. Usually what a preliminary injunction is used to do is to maintain the pre-litigation status quo, or the pre-dispute, more accurately, status quo. Because with the idea being, keep everything the way it was, run the litigation through to the end, and then make whatever changes. So you need to show 4 things to win a motion for preliminary injunction. First thing you have to show is that you have a likelihood of success on the merits of the case. That doesn't mean you have to show that you're more likely to win than not, but it means you got to show you got at least a chance, and a decent chance, not just a faint chance. So you have to basically pre-argue your entire case, and do it reasonably well. You have to show that without that relief from the injunction, you will suffer irreparable harm. What is irreparable harm? Irreparable harm is any harm that is not reparable. Harm that is repairable is short version. If you can fix it with money, it's not irreparable. If you can't fix it with money, it's probably irreparable. So you got to show the kind of harm that you can't fix with money. You have to show that the balance of the equities favors you. What does that mean? Basically, you need to show that it's more fair to freeze everything in place than to let things continue to go on the way that they are now. And finally, you have to show that the public interest supports the injunction. Factors 3 and 4, the balance of the equities and the public relief, are fuzzy, often result driven, meaning you know it when you see it. The court can argue backward to it. The critical factors, really, the most critical factors, are success and harm. Without those, yeah. If behavior from the defendants gets worse between now and November 26th, could they file for a TRO? Yeah, but you're going to burn credibility with the judge. Okay, so again, for the non-lawyers, because I got a lot of the WordPress crowd in here right now, right? If you haven't been on the stream a lot. Credibility is your currency as a trial lawyer. Your credibility is, you start with a very small balance. You have to earn more. When you spend it, it is gone. And it is very hard to get back. When you've got a pending motion for preliminary injunction, any additional harm that would have to be extreme, and it would have to be different, not just in degree, but different in kind from the harm that you've been talking about in the preliminary injunction motion before you would want to even think about moving for a TRO when you've got the hearing already calendared. You absolutely have to. And yeah, I mean, the Young Thug trial, the prosecutor's got no credibility left, and you see it every time she opens her mouth. I don't even watch it much, but every week or so I look at one or two videos, and she is all the way down the hole with the judge, and she just keeps digging. You don't want to lose credibility moving for a TRO at this point unless the justification is enormous and facially obvious, would destroy credibility. All right, so background. All right, so plaintiff recently filed the action. In short, in recent weeks, defendants have engaged in a self-proclaimed nuclear war aimed at destroying WPE's business because WPE dared to stand up and speak out against defendants' extortionate demand for tens of millions of dollars annually for a reported license WPE does not need. Oh, Rachel, if you're still here, I forgot one of the other little details. So Matt Mullenweg told the world that he was donating the WordPress trademarks, to the WordPress Foundation, that they were going to go to the public so that the WordPress trademarks would never be owned by anybody and everybody could use them. And then the very same day, he gave Automatic an exclusive commercial license. An exclusive sub-licensable commercial license. I told you I was just scratching the surface at the start. Fully paid, non-revocable, yep. No royalties. The consideration for the license was them getting the non-commercial rights. Oh man, this is messy? Yes, it is messy, and this is one where all of the good facts are on the same side, and it's not Matt's side. Oh yeah, he did this as a board member of the foundation to the corporation that he's CEO from. Yeah. There was consideration. Saying that the consideration literally was the foundation gets the non-commercial rights, but that's consideration. That's sufficient consideration. It's not going to be void for lack of consideration. Fraud, on the other hand, through these attacks, defendants have committed multiple... By the way, read the complaint. The complaint is good. I mean, the CFAA claim is but, though they only had the non-commercial rights because he gave them the trademarks. He assigned them the marks. So the license back was in exchange for the assignment forward, basically. License backs are not at all uncommon in trademark, and I think it's more than sufficient to support consideration. All right, so anyway, WP does not need the license, yeah, because pretty much everything that they do is... because everything that they do pretty much is nominative fair use. Anyway, defendant scheme, brazenly memorialized by Mullenweg's own text messages, gave WPE less than 24 hours to either sign the license and pay up or face scorched earth nuclear war. Through the attacks, defendants have committed multiple wrongful and illegal actions that they admit were designed to destroy WPE and take its customers away. Blocking their access to business resources, including those used to service customers, blocking customers from accessing security updates, litany of false and disparaging statements, and expropriating one of WPE's most popular software products as its own. Facing the retaliatory actions, WPE sued. Like I said, they actually sued about 3 or 4 days later than I thought they were gonna. Ordinarily, a rational action... I love this paragraph. I'm reading this for the first time, by the way. Ordinarily, a rational actor on the receiving end of a federal complaint asserting multiple serious causes of action, such as cyber extortion, defamation, and intentional interference with contractual relations, might pause to consider whether their course of conduct was prudent. Defendants engaged in no such self-reflection here. They instead doubled down, attacking WPE with escalating frequency and fury since the complaint's filing on October 2nd, while publicly reaffirming their extortionate intentions that this can all go away if WPE pays up and drops the suit. Facing multiple forms of irreparable harm, including loss of customers, market share, and goodwill, I've argued that I've argued for irreparable harm based on loss of goodwill. There is case law that says that even without trademark claims, loss of goodwill can constitute irreparable harm. Despite immense public outcry within the business community in which the parties operate as competitors. Yeah, that's the other thing. Just for additional clarity, Rachel, Automatic and WPE are direct competitors in the same marketplace. Factual background. I can't do too much of this right now. I'm going to skim for stuff that's new to us. WP Engine is, it's a venture capital backed platform. Mullenweg is entities and his resulting conflicts of interest. Automatic is a for-profit company that offers WordPress related services. Mullenweg founded it and is its CEO. Mullenweg also founded and is a director of the WordPress Foundation, which claims to be a non-profit entity dedicated to educating the world about WordPress. In 2010, I was off by a year, I'm sorry. In response to mounting public concern regarding the private ownership, the source code and trademarks were reportedly transferred to WordPress Foundation, with Mullenweg and Automatic making sweeping promises of open access for all. Automatic has transferred the WordPress trademark to the WordPress Foundation, the nonprofit dedicated to promoting and ensuring access to WordPress and related open source products in perpetuity. This means that the most central piece of WordPress's identity, its name, is now fully independent from any company. Mullenweg and Automatic reiterated this promise later. What's important is that longer than I'm alive, longer than Automatic is alive, longer than any of us are alive, there is something that holds the WordPress code and trademark for the free access for the world. That is what I would call an promise. Promise would be the word that I would use for that. Because the thing is, not all promises are contracts, but a lot of promises can stop the fuck out of you. File that under bad facts? Yeah. File that under catastrophic for two. I object why it's catastrophic to my case. This is, unless there was just a ton of more context to those remarks, That's the fucking ball game. Um, I mean, that right there is the ball game. What ball game are we talking about? That's the promissory estoppel claims. Um, for sure. Or as close to for sure as, yeah. I mean, this is the kind of thing that makes you tempted to forget that you can't guarantee clients' outcomes. What I wouldn't give for facts like this. This is as clear of, there is something that holds the WordPress code and trademark for the free access for the world. That is a promise. It is a promise that is made with the clear intent that the people who hear the promise rely on it, that they take actions in reliance on that promise that are to their detriment, and in this case are damaged as a result. Yeah, promissory estoppel is hard to prove. This is not hard to prove here on these facts. Could he have a legitimate defense for that? No. Not for the promissory estoppel. Not for the trademark. The promissory, I mean, that may be why he's backpedaling to he personally has the sole right to control all the use. But that's boy, Hogan's got a hard uphill push to make. Yeah, the code is well, and it's about the website now, and they're adding in the fact that they're now claiming that all of WordPress.org is personally owned and personally controlled by Mullenweg, which is the kind of thing that sounds like a great idea if you're a lawyer who is extremely disconnected from the industry that your client works in. Because it's the kind of argument where you look at the argument, and if you know what your client does, you refrain from making that argument, because that's the kind of argument that can just kill your entire client. Like, that type of argument is the type of argument that goes Pyrrhic victory. I mean, that's the sort of thing that you are almost shooting for at that point. What are the repercussions for losing his case? He has to reset everything back to where it was pre this dispute. And yeah, we can make this argument, but at what cost? And I'm not just talking about, how many $2,000 hours are we going to spend on this? And I don't think victory is close to assured with that argument either. I think it's a dumbass fucking argument. What defendants' assurances did not disclose is that while they were publicly touting their purported good deed in moving this intellectual property away from a private company in the safe hands of the nonprofit, they had quietly transferred irrevocable, exclusive, royalty-free rights right back to Automatic. Until recently, defendants had given the community the impression that WordPress.org was owned and controlled by the foundation. The reasons for that belief were numerous, including the fact that the site has a .org. The statements that the code was owned by the foundation for free access, his role at the foundation, his promotion of WordPress as an open source software platform that's free and accessible, automatics. They deleted it? Oh, shit. Mysteriously, yes. Mysteriously is one of those words you put in the first draft, you take out in the second draft, and in the fifth draft you go, oh no, that's going the fuck back in. I can't. Oh, I covered that one. I said that was that. Yeah, that when I covered it at the time, I covered it. That was the most sweeping issue. That was the most alarmingly dangerous thing that they had said. They decided to go. Yeah, a very well earned bit of sass. So it came as a surprise to most in the WordPress community when Mullenweg revealed recently that he personally owns and controls WordPress.org and pays taxes related to it. This disclosure revealed an inherent troubling conflict between Mullenweg's positions as a director of the nonprofit, Mullenweg's role as CEO of Automatic, and Mullenweg's quiet ownership and control of the for-profit WordPress.org website that hosts WordPress and the community's plugins, acting as a portal to the entire community that Mullenweg alone wields power to restrict. Defendants' awareness of the use of the trademark. Everybody knows where WPE's been using the trademark for like a generation, in internet years anyway. The coercive threats we talked about. They carry out the threats we talked about. False and disparaging statements we talked about. I think the disparagement and defamation claims are weak, but they're colorable. Defendants block access to the plugins. And tried to update their access their WordPress.org accounts, only to learn that their accounts had been disabled. Stated another way, if WP identified that one of the plugins it created had a bug or a security issue, it would no longer be able to publish an update. This could cause the websites to stop working without any easy way to rectify it. They were forced to find workarounds to service customers and update plugins. That's called reparable harm. That's money you spent. That's not irreparable harm. Nowhere on the developer website does it say that a plugin developer must pay Mullenweg's for-profit venture Automatic to host their plugins, or that a developer can be excluded if Mullenweg unilaterally sees fit. On September 25th, Mullenweg banned WPE customers who host installations on WPE servers from accessing WordPress.org resources through the admin panel, which includes themes and plugins, including those developed by WPE. Defendants intentionally sow fear in the marketplace. In a recent interview, Mullenweg claimed that because of the success of his nuclear war, he's no longer satisfied with 8% of revenues. The deal they have to do next could be taking over the company. This dude is on crack. Asked how he could cause WPE's value to sink to the point where it would have to sell itself to defendants, Mullenweg said he had more cards to play. I have a lot to work with. Elsewhere, he bragged he was making WPE a distressed asset worth only a fraction of its prior value. As another example, openly invited the WordPress community to brainstorm how to manage a mass migration away from WPE's ACF plugin, predicting millions of sites moving away from it in the coming weeks. He told WordPress community to use any other web host in the world. When asked why developers would invest time moving away from WPE, he responded ominously, I guess you'll have to wait and see why people might not trust ACF as much going forward. ACF, that would be irreparable harm. That is reputational damage, and that is, at least plausibly in my view, reputational harm. Manufacture a sham security review of the plugin. After WPE filed its complaints, defendants did not so much as even pause their wrongdoing for a moment of self-reflection, began sending purported security alerts about the WPE's ACF plugin. Where did we hear about that? We heard about that, the paragraph above, with the last sentence is Mullenweg saying, I guess you'll have to wait and see why people might not trust ACF as much going forward. This is... Quinn is expensive. Quinn is earning their money. You have no idea how much it rips out of my soul to say that Quinn is earning their money. Hurts my small law. It hurts me in my little shriveled small law heart. But Quinn is earning their money on this. Quinn, if you happen to listen to this because you're, vanity searching, my hat's off, but I still hate your guts, and I'm still looking forward to kicking your guys' asses. That's a joke. Yeah, you do occasionally gotta hand it to Quinn Emanuel. I try hard to hate the big law firms that are on opposing sides to me in cases. But this team at Quinn isn't actually the team that I'm up against anyway, and they're doing decent. So background for the chat. Our firm is representing a significant number of former Twitter employees, and Quinn is, Alex Spiro is Elon's lawyer. So, let's see. Recently, Automatic began sending purported security alerts about the ACF plugin to the CEO in another act of harassment. The security vulnerability was minor, and WPE released a patch within 72 hours, and despite being unable to access .org, managed to have the patch provided to WordPress staff for distribution through WordPress.org. But before WPE could release the patch, in an unprecedented and dangerous move, defendants publicly announced in a social media post that they discovered a security vulnerability. The action of publicly announcing it before it could be remedied was unprecedented, inconsistent with good practices, adequate practices, real practices across the entire industry, and potentially dangerous to users. Hackers can take advantage of this to attempt to hack websites before the patch is released. Mullenweg eventually took that down. Modifies WordPress.org's login page to require loyalty pledges disavowing affiliation with WPE. Changed the login page to require all WordPress users take a loyalty pledge. That is, began requiring all WordPress users to check a box agreeing that I am not affiliated with WP Engine in any way, financially or otherwise, and blocking login if the box is not checked. So, under threat of unspecified legal repercussions, they've pressured WPE's customers, partners, vendors, employees, and users to either cut ties with WPE or be banned from using any resource on WordPress.org, including the code and plugins which are supposed to be open. And yeah, unnecessary changes to a login interface. What could possibly go wrong? Oh yeah, and they directed users to ask WP Engine to tell them about it. Nobody has any idea. Yeah, I mean, what does affiliated mean? In the legal sense, I'm not affiliated with WP Engine. Do they think I have no idea. On October 12th, they then, on October 12th, they then took over ACF. Where have we heard about ACF before? Oh, yes, in these paragraphs and that paragraph. Defendants place themselves in control of the plugin and updates thereto, thereby directly interfering with the relationship between WPE and millions of its customers and prospective customers. Admitted doing so to target WPE specifically in retaliation for WPE pursuing the lawsuit. Quote, this is a rare and unusual situation brought on by WP Engine's legal attacks. We do not anticipate this happening for other plugins. Forcibly took control of ACF through the ownership of .org, where ACF is hosted. Then they misleadingly rebranded it as Secure Customs Fields, justifying that based on the security thing. The new page falsely states that SCF was developed by WordPress.org. It was not, and they retained all the download counts and user reviews for the plugin over the 12-year period. That is pretty clear false advertising, I think. They probably would have to amend to add it, but that is fairly false advertising. Yeah. Co-opted the plugin's unique identifier and published an update, meaning that everybody got migrated to the new rebranded plugin without consent or knowledge because the update appeared to have come from WPE. That actually might get you to... That might get you to CFAA. I didn't know they had done that. I'm coming at this cold. That might get you to CFAA. I don't know that it does. There's some iffiness in there, but that feels more hackery. And the more hackery something feels like, the more it starts to feel like the Computer Fraud and Abuse Act is a good fit. I think there are issues with the CFAA. And in general, I think there are issues with the CFAA claim here still, but this gets the part where you might be able to get to the access to the computer is the taking it over and then pushing the update. That's the bit that might just get there. I mean, I'm wishy-washy on it, but that's a ton stronger than the claim they started with, for damn sure. Yeah, I mean, it's a big, red, obvious line to cross. And in yet another act of interference, they removed... Holy shit! Holy shit! He did what? my God. No, this ain't CFAA, man. This is tortuous interference with prospective business relations. This is 100% tortuous interference. This is tortuous interference in like 50 out of 50 states. Oh, oh my God. That is. Hey, Rachel. Did that kill you? Because I think it killed me. I think I'm now streaming from the afterlife. Tortuous interference is another very difficult claim to prove. In many states, you have to actually show, wrongful conduct. But the wrongful conduct here is the wrongful conduct here is clear. The wrongful conduct here is the false advertising and the trademark violation at a minimum before you get to anything else. I mean, there's all kinds of tortuous underlying conduct, and then using that conduct to take over the plugin, they have now disabled the ability to buy the pro version, thereby deliberately interfering with the prospective business relationships, which they know about because they deactivated the ability to buy the pro version. This is what did he do? He took over the ACF plugin, then he removed users' ability to purchase the pro version of ACF from the original developer. And this is, completely, this is like, I don't know how you would check the boxes for tortuous interference with prospective business relations. And I mean, tortuous interference with contract is tough. Tortuous interference with prospective is ludicrously difficult. But, man, he's checking the boxes. Wrongfully usurped the relationships and goodwill developed between WP and its millions, conveying the false impression that the plugin was developed, and violated their own open source guidelines, promises, and basic tenets, while openly admitting it was to retaliate. Oh yeah, in some jurisdictions, in addition to a tort, you also need ill will. But they've like, I think they've managed to create something that is tortuous interference in, if it's not in 50 out of 50, it's because of Louisiana. The Vic Mignonia tried tortuous interference and he was at negative 18. This is at 98, 99. Like, even going into everyone's mailbox and ripping up a mailer is not necessarily interference with perspective. Why Louisiana? Because their civil law, they're always weird. Can I be completely honest? If the case is far from what I would usually see, or is this craziness pretty dated? This is, y'all, my law firm kind of has a thing where even cases that should be normal are not normal. This would be weird by our standards. Okay? This would be weird by the standards of the stuff that my firm touches. This is absolute, complete Fledermaus Scheiße. This is so much of it that it's using up the global supply. Defendants threatened yet more harm. On October 7th, bragged that he caused chaos while he was still on vacation, promising more surprises Tuesday, Wednesday, Thursday. On October 14th, promised, oh, there's more. Have started contacting WP customers to induce them to terminate their relationship and contract with Automatic instead. Using fear tactics, among other things, noting that WPE's ban from WordPress.org that defendants themselves caused could impact sites, plugins, or updates. Added veil threats that while the ban... Do you know what I'm reminded of? Do you know what pop culture what pop culture, this isn't Bond villain, okay? This is not Bond villain nonsense. Okay, pop culture, yes. I'm reminded of a pop culture thing looking at this, okay? And yeah, this is 100%, that's a nice website you have there. This is Snidley Whiplash wasn't where I was going. Does anybody remember the Beagle Boys? The Beagle Brothers? Anybody remember them from Disney? That's what I'm reminded of. Oh, they go all the way back to the Golden Age. Yeah, they go all the way back to the Golden Age, I think. Might not affect your site in the short term, emphasis added. Good use of adding emphasis. But yeah, it's that level of deranged, okay? This is not superhero supervillain nonsense. This is not comic book superhero villain nonsense, okay? This is Sunday Comics funny pages villains. Is what this is. This is comic relief cartoon villains. Not comic book, cartoon. Yeah, childish, not childlike, with its connotations of innocence and... Oh, hang on a second. That's my wife, so I'm going to put this on pause real quick. Hey, sweetie, I'm streaming. What's up? Okay. Cool. Talk to you when you get home then. Love you. Bye. Yeah, I was going to cut the mic if it wasn't hot, but me taking a call from my wife, no matter how many people are going to, watch this on VOD later or whatever, is a priority over y'all. And I'm not going to apologize for that one. I'm a wife guy. All right. This is not childlike behavior. This is childish behavior. WPE also understands from multiple sources that defendants are plotting more harmful acts. That's going to be more insider threats at Automatic. Including, among other things, forced takeovers of other WPE plugins and additional bans from other resources. Have caused and will continue to cause irreparable harm. Cancellation requests increased by 14% year over year. Lost new customers. Sales-assisted business channel saw 63 potential new purchases or upgrades lost, where during negotiations those lost customers expressly cited defendants' actions as a reason for pulling back. E.g., I'm not sure I'm comfortable until all this drama on your guys' end with WordPress is figured out. I've had a bunch of website issues this week I'm not used to having, and clients contact me. It's costing me money. And those are just lost ones that are doing that. That's money. That's reparable to an extent. Self-service signups dropped 29% from the prior September. 375% increase in installed tools that will allow them to migrate. Public posts have shown customers saying things such as, the takeover gave me a minor heart attack. For his part, he provided a forecast of his own making, claiming that millions of customers will lose trust. That right there is a form of irreparable harm. Night, Rachel. Actively encourage defections, including to increase their market share by offering to pay to breach their contracts while WP is blocked and moved to service providers owned by Mullenweg. Wrongfully usurp the goodwill and brand recognition. That's irreparable harm. Undermine the integrity and reliability of the plugin, which is reputational harm, which is irreparable harm. At what point did they let Matt write the lawsuit? They did. Additional takeovers of the plugins would further interfere. Customers have been harmed. Website operators stand to lose their own goodwill with their customers. Increased monitoring efforts, etc. The WordPress community is being harmed. We've talked about that. Their excuse does seem to vacillate. Legal standard. All right, likelihood of success on the CFAA and extortion claims. So they're leading weak and they're finishing strong. There are different ways to write. That's one of them. To damage a computer means any impairment in the integrity or availability of data, program, system of information, and provides for injunctive relief. So what I'm looking for is what protected computer specifically are they claiming? Although well, remember, they're confined by their CFAA claim as pled. They might get the chance to, when they get the chance to replete it to include the new stuff, the strength goes way up. But this is on the original as pled, which is wishy-washy. Unfair competition law. I'm not a California lawyer, but this feels a hell of a lot like unfair competition. Every computer that has the plugin raises standing questions, because remember, you can sue to repair harm to yourself, not harm to the universe. Only the universe can sue to repair harm that is to the universe as a whole. And the universe seems litigation adverse. But the extortion is, I think, plausible. The unfair competition law, this feels a lot like unfair, unlawful, fraudulent business practices to me. I mean, I don't know the specifics of California UCL, but the local state UCL statute would be because almost every state has a UCL claim. Sometimes they're in what's called the Little Sherman Act, the Big Sherman being a federal statute. Sometimes it's just it's UCL, unfair competition. Sometimes it's UMOC, unfair methods of competition. But most states have these statutes. I can't say how strong this claim is under California's because I'm not a California lawyer and I haven't had to work cases where California's statute was in play. But I would say that whichever state I'm in for a case like this, UCL is one of the first statutes I'm looking at. Because this very much feels like UCL. Broader than the combined effect of other laws, it's unfair when the conduct violates the policy or spirit or is comparable to a violation of the antitrust laws, or otherwise significantly threatens or harms competition. And Matt has now said that he exclusively controls .org. And of course, the false impression that defendants developed the plugin is also pretty strong. False advertising is there. The interference claims, oh my god, yes, they are so likely to succeed on interference. Irreparable harm, loss of customers, loss of market share, damage to reputation and goodwill. Work for me. Equities tip in favor. Yeah, equities tip in favor here. What you argue is, well, they're arguing death of 1,000 cuts on WPE, which is balance of the equities there. Public interest, customers at risk. I would have argued also ecosystem and more, but they're probably, given that they finished at 25 with the signature block on the next page, they were probably at the word count max. All right, questions. I'll have a better feel for how strong this is, by the way, when we see the opposition, Halloweenish. What's the word count max? It's somewhere. It varies from court to court. I would have to go look at Northern District of California's local rules again. New York State filings, just because I'm familiar with that off the top of my head right now, you get 7,000, 7,500's a common standard, and 7,000, 7,500 would come in at about 25. It might even be that it's a 25-page standard with a font size. Different courts have different requirements, but 25 is right about where I would expect the word count max to be. What is about it? So what is it? So how long do you think? How long would a case like this be expected to reach conclusion? Depends on how you define conclusion. My guess, I'd be surprised if the case is still ongoing in 2030. I'd be surprised. Response filing and motion to dismiss filing are both due on the 30th. Is the remedy going to be cash damages? Well, the other injunctive relief is the other thing besides cash damages. Injunctive relief is the court says, stop doing that now, or I'm going to start using the words like contempt. It's a judicial order to stop doing the bad thing. What is it about his position that makes it interference? Like Joe Schmo can talk stuff in free speech? Yeah. But in this case, he's doing it to his commercial advantage. He's doing it to his commercial advantage. He's using the false trademark claims to do it. He's doing it by blocking access to the thing he now says he's got the right to block access to, but that goes to the promissory estoppel claim. So, I mean, generally speaking here, what he's doing, even if nothing else is interference, there's interference in the not letting people upgrade to the paid version. What is it that makes it tortuous? Generally speaking, it's other wrongful conduct. In California, though, I understand you don't need independently tortuous conduct. So, that's a thing. For that matter, yeah, there's a few different things. So the remedy won't necessarily just be cash damages, and they're not asking for cash right yet. Have I seen the supporting documents? Yeah, I mean, I've got the Brunner deck up here. I'm just not going to have time to cover it today. Anything that was important in here is going to have been in the brief in chief. Because the agency partners thing, that's additional detail to a thing we've already mentioned. Does he have a contractual relationship with them already? With who? I mean, Evil, you're going to have to be more specific in your questions, please. I'm sorry. Um, Met can't be replaced legally. Is that right? I don't know what WordPress, what Automatic's corporate structure and corporate rules are. WordPress Foundation, I don't know what their. I haven't seen a copy of their bylaws. Do I think there's any validity to improper financial use of nonprofit side? The issue is that that's not really going to come up that much in this case because I don't think WPE's got a huge got standing to raise much of that. Are they going to get in trouble for it later? Are other people going to bring stuff up? Different question. But I don't think that's going to be a big factor in this case because again, the state of California and the United States government might have standing to pursue tax issues involving the trademark stuff that not showing up on their books and everything. But WPE probably doesn't have standing to raise that. Given that I'm pivoting away from politics, do I plan on saving VODs more? I may. A lot of it I just never ever get around to. A lot of it's time on my part, guys, and inclination. Right now, I do this because it's still fun as a hobby. I don't want it to turn into work. That said, what I may do is I may just slap Creative Commons licenses on everything. Are you sure, Evil Mouse? Because I mean, if you restate it, I might answer it. I just was having trouble tracking it. So feel free to re-ask it. I was just having a little bit. Take your time, put it in a single question, I think would be my request. Automatic invested in WP has come up. I do not like Spiro, but I'd love to see him cross Mullenweg, maybe. Replaced legally as owner of the org. Yeah, I don't think that can. If he owns it personally, I don't know that can happen, y'all. I'm not sure what would. That's an interesting legal question. Could he be compelled to turn it over to the foundation? I don't know. That would be the most I would think could happen, but I'm not sure. But again, we have to distinguish now because right, everybody's been shorthanding WordPress Foundation as .org for like 15 damn years. And now we find out that they're not the same thing, and everybody's confused all again. So yeah, resolution time. I mean, I would expect this to be active at the trial court level for 24 to 36 months, and then appeals. Thanks for the gift sub, Illuminous. Appreciate it. What are possible consequences that Matt could see if he loses? He loses a ton of money. That's the big one. How could all that laughter feel like work? Right, it doesn't, which is why I do it. Figuring out how to download my or how to remembering to check the recording button, upload the recording to another website, and all the rest of that is where it starts to. Yeah, lots of money and also court orders to stop the FOs. Yeah, go ahead. If you want to strip the first hour, go ahead and strip the first hour. We'll call the license on this one just a straight up non-commercial. Yeah, NC BY. There you go. So that covers the derivative from stripping out the Blade Runner. Okay, you lost the context. That's fine. Sorry, man. Or if man's not, sorry, person. Watching this whole thing since September, and yep, glad to be here. The case isn't against .org either, it's against Matt, but Matt says Matt is .org because .org is not the foundation. Am I planning to stream on Halloween? Probably. Could he be compelled to point to other sources and plugins? You can get creative in injunctions. How much is going to fall against Met personally versus Automatic? It depends. Don't know. Am I going to do the next stream in the Stormtrooper helmet? So that Stormtrooper helmet... Hang on. Are we far enough to the end for me to do the Stormtrooper helmet? And see how much I destroy on my bookshelf if I take it off? Because if I've got new people, y'all don't know what helmet that is. Could I talk a little bit more about fiduciary duty in a theory way? Fiduciary duty is a very murky subject area. It really, what it really comes down to is that you've got a duty to put the organization or whoever, as a lawyer, I have a fiduciary duty to put my client's interests before my own. So there's a lot of fuzziness. Do I think that Matt is in breach of fiduciary duties? I don't see any way he can't be. Which duties he's in breach of, who he owes those duties to, different and more difficult question. Which requires a lot more of a deep dive into what responsibilities he's had. I would need like a whiteboard and a map and markers and string to probably figure out which ones he is and if there are any he isn't in violation of in some way. But without doing the map and the string stuff, figuring out who's got standing is more difficult. Red string push pins a cork board. It's a very difficult area, and in this particular case where he's got duties to the foundation, duties to Automatic, I don't know which other companies he might have duties to, and I don't know how the things he's doing interfere with those. I just know that there's virtually no chance that none of it's interfering with any of it. All right, so the helmet. In the world of prop replicas, this is a serious replica. And by a serious replica, I mean this is manufactured by the guy who did the original, and it's stamped out of the molds that were used for the original. So what this thing is built to the specs of this is built to the specs of the helmets that they built and detailed out for the heroes to use. So the funny thing is that the 501st will not accept this helmet as part of the costume because it's not accurate enough. No kidding. And I thought that was hysterical. I learned that from a 501st guy at Comic-Con London. While I still had this on order before it was delivered. And then when it showed up, I realized why. Because look, does this look good from where I'm sitting and where I'm standing right now? Does this look like a seriously good Stormtrooper helmet? You're not going to find one that looks closer to the thing in the movie, right? But from where I'm sitting, it actually looks kind of garbage. These things are just decals, and if you look closely, you can see that they're raised up as decals. Um, this actually looks pretty cheap. It almost looks like it's a stuck-on paper sticker from here. If you look at it closely, you notice that it's asymmetrical because he actually didn't quite get it to match when he did the molds the first time. So it works great on camera, but it looks bad in person, right? But I will tell you that when this thing arrived, now this is the model that they used for Han and Luke for the characters. It's called the hero model. So this is the one that, that Mark Hamill is wearing wandering around the Death Star, that Harrison Ford's wearing wandering around the Death Star. So I did this, and the first thing I said was, I can't see a thing in this helmet. Because you really can't. The visibility is incredibly poor. So yeah, and that, by the way, the whole it's a movie prop thing, the reason that I've got it, you can breathe, but barely. The reason that I got it is because it featured in a UK Supreme Court case that turned on whether or not that was sculpture or a useful article. So anyway. So yeah, it's press formed. Yeah, it's vacuum form. It's vacuum form plastic. So, so it's original helmet, but it's original helmet. Andrew Ainsworth, who was the original designer, has a company, makes them. He can legally sell them in the UK. He cannot legally sell them in the US. So let me see. There was another legal question, I think, just before I did that little digression. Philosophically, do I think law follows morality, or is law separate from morals? Law is separate from morals. I'm a legal realist. I'm not a natural law guy. Law is what judges do. Off-topic question time? Sure. Although I would point out that digression was actually on topic for the stream as a whole, because this is really the centerpiece of a major copyright dispute, and a thing where the intellectual property law status of the item is different in the US than it is in other countries. The carpet is... Oh. The carpet? We'll do that one another time. What research you should do for yourself or talk to the lawyer so you can maximize the time. You're going to put together a business plan. Let me see. Honestly, the point to talk to the lawyer is sooner rather than later. Most lawyers, because that's the kind of thing where you're going to want to reach out to somebody locally who does business setup. Depends on which, who's going to be good, depends on which state you're in. If you need referrals, ask around, or often the local bar association has a referral service. For business plan and business formation stuff, go to the lawyer early. Most lawyers will give you an initial consultation. And the initial consultation will cover a certain amount of stuff. In terms of what research you should do, depends on the questions. Exactly. Nintendo versus Blockbuster. Restaurants need a special license for the copyright. Barcade owners are mum but opening the kind of business, so there's a way. Yeah. So start. I would really still encourage the start. At some point you might want to talk to somebody like me. But a lot of the basic business stuff is going to be state law, and it's going to be local stuff. That's going to be stuff like getting your business entity formed early. That's a huge step right there. What licenses are you going to need? locally to open. Um, yeah, what licenses are you going to need to open a barcade locally? What's going to be involved in a liquor license? Those are all local questions. And honestly, those are probably questions that you want answered before you dive into the high level IP stuff. Or, speaking as a guy who does the IP stuff, if you were coming to me, that's what I would suggest first. Hurts my soul to send people, but that's that's really the right starting point. In terms of the IP stuff, yeah, you do need generally you need a performance license to do stuff. And if you wanted to research, look at ASCAP and BMI. But now we're at the limits of what I'm able to tell you without us having a private conversation where privilege would attach. You can reach out to me if you want, but what I would really encourage you to do is look for somebody local first. There may be somebody local who does enough IP on the side to give you good advice in that area. If you get to a point where you've got everything else worked out and that's, the bit that you're at, that's when you might want to reach out to somebody who does more IP work than other stuff. But yeah, I would worry much more about the bar side of the bar. So I would very much encourage you to find a local attorney who does business formation, and preferably somebody who does liquor licenses, because that's going to be your biggest hurdle. If you want to ping me with what state you're in or what have you, I might know somebody, but most likely Google still works. Check the state bar, so when you're looking at things, check the state bar association will tell you if anybody's got a public disciplinary record at least. And yeah, go ahead, and go that direction. But the earlier you talk, the earlier you talk to the lawyer, the better. Because honestly, and one of the other things that the lawyer can tell you, a lawyer you talk to can tell you, is how much to budget in your startup budget for legal. Because one thing that I will tell you that I've seen, and I've seen enough times that it hurts, is people are like, it's going to take me $20,000 to start up. I can only raise $20,000, so I'm going to start up with $20,000. I'm not going to try to raise an extra $5 or an extra $2 even for legal. And the thing is, $2,000, $5,000 at startup for legal can fend off the type of spend where the spend itself becomes an existential threat to the business if things go wrong later. With politics, it becomes more complex because there's special provisions in the ASCAP and BMI licenses for that stuff now. But yeah, sorry for the mini rant on that one. It's just, I tell people, you can pay me $5,000 now, or you can pay me $500,000 later. And the number of people who seem to elect later is distressing. I would much rather do advice and counsel work early than defense litigation late. That would be a great Halloween story, man. Undead Sinead O'Connor hunting down someone. All right, any other questions? Yeah, way too many people go for the pound of cure over the ounce of prevention. As I mentioned, Monday I got resold on the value of the ounce of prevention. That's during the parts of Monday that I have memory of. There are other parts of memory I don't have so much memory of. Turns out propofol is a hell of a drug. And yeah, absolutely, you can save $5,000 in consulting fees by being prepared to spend $200,000 at trial. All right, thanks for sending me the link would be good. Next stream I'll probably cover this. The other thing is that one of the advantages that I've got to shifting to the more tech focused stuff is that we've got so there's a case, it looks like a really bad one involving a suicide and character AI. That's a case where I know aspects of the case that are going to deal with things like Section 230 of the Communications Decency Act and the internet law aspects. What I'm not going to know as well are the personal injury, wrongful death aspects of that case. However, Thomas Neville, who is one of the partners at our firm, has done quite a lot of personal injury work. So what I'm thinking is, at this point is that, and he and I chatted about this for a few minutes this morning, we'll wait for the motion to dismiss to come in because that gives us a better idea of the direction the case will be moving. But he and I might might stream together on that one and talk to that one. He says the complaint is really well drafted. So, Thomas making a guest appearance, quite potentially. We've tentatively penciled it in for when the motion to dismiss is filed, and cover basically the complaint and the motion to dismiss in the single stream. I know that's not as exciting as doing the read up front on a complaint, but as a lawyer, you get a better feel for the strength of the whole case when you've got the two of them together. And yes, Monday was colonoscopy day. Sunday night was terrible. Monday wasn't too bad. However, I now understand why. I now understand completely why they tell you after that somebody should stay with you for the rest of the day and you shouldn't do anything requiring judgment. Because, boy, I ordered a lot of pizza on Monday. Not sure what my logic was on that one. Boy, did I order a lot of pizza on Monday. Also, seem to have done a couple of things that I do not remember doing, including like painting an entire miniature. Like there's a mini that I painted 3/4 of on Monday and I've got no memory of it. Yeah, I remember that I told my wife that my plan at the start was that I was going to order Papa John's because I hadn't had Papa John's in a very long time. But I ordered a hell of a lot of Papa John's. You know. Yeah, pizza and mini crating, man. I'm a wild and crazy guy when I'm on drugs. What can I say? All right. Any other questions? Questions going once. Getting Papa John's was a plan. Salty, in my defense, remember, I'm on base. I'm on base. I was not allowed to drive. And Uber Eats and that kind of thing is hit or miss on base because you got to get a driver who's got base access. Papa John's, I know for a fact, has a driver that has base access. So I know I can order from there. I can't necessarily order from Big Kahuna, which would be my vastly preferred. I'm a New Yorker. Big Kahuna does deep dish. They're still my favorite pizza place on the island. Kapua, you want to say hi and bye to the people? Hi. Yes, and let's see. Which camera? We got the peoples in this camera now. Yeah. You want to say hi to everybody? You want to say goodnight to everybody? That's a good girl. That's such a good girl. Yes, you are. You're such a good doggy. Okay. Whoa. All right. Yeah, there's the good girl. All right, everybody. That's going to do it for me. Have a great rest of your night. Have a great rest of your weekend. I will be back on Thursday at the same time. Probably. When does the rest of America go to daylight savings or go to standard time or whichever you do? I can never remember. It's sometime in November, right? I've got a while. Before I have to figure out whether I'm going to move the stream later or earlier or whatever I have to do, or whether you guys get to move after Halloween, fine. So next week, same, November 2nd, November 3rd. Okay, early November. So yeah, I'll figure out, I'll tell you next week what I figure out on that one. Until that stream next week, have a great rest of your week. Have a great weekend. Mahalo for watching, and aloha.